Welcome to You and the Law. This is a program presented by the Chicago Bar Association. I'm Barry L. Gordon, a member of the Chicago Bar, and I have my own firm, Barry L. Gordon and Associates in Chicago, whereby I concentrate in family law, medical malpractice, and personal injury. In January of 2016, we all know that divorce laws changed dramatically, and the lawyers and the judges have been studying the problems that are occurring as a result of these new laws. We're going to discuss today what these problems are with the new legislation and what it's brought to our table. We have with us today Mr. John Wroblewski, and he's from the law firm of Jakubs Wigoda in Chicago. John's been practicing law for over 11 years, and he is a certified child's representative in Cook County. John, thank you for being here today.
It's great to be here, Barry.
John, we're going to talk today about this interesting subject as to how it has affected. Now it's been a year since the legislation's been enacted, how it's affected the judges and how it's affected the lawyers and the litigants. And I think that we need to get into that because it's not all good and it's not all bad, and there may be a dividing line in between. We're going to talk about settlement agreements, and we're going to talk about parenting agreements and the problems that lawyers have with those two items. So let's start by asking you, now that custody is gone, by that what do we mean?
Well, now what the legislation did is it broke down custody into its common elements, which are allocation of parenting responsibilities and also parenting time itself. The different subparts are education decisions, decisions regarding extracurricular activities, decisions regarding medical choices for the kids, and also religion. You know, obviously the religious aspect is tricky, but those are the basic four.
All right, based upon what you said, I want to stress that the word custody is gone.
Correct.
We don't use custody anymore. It's a no-no. And the categories that you talked about, you call them subparts, I think?
Yeah.
Yeah, they're actually very important in the Act, and we have to address them as lawyers. In other words, we have to divide up the responsibility of each one of these categories, which you indicated is education, health, religion, and extracurricular activities. Let's talk about education for a moment.
Okay. What
type of, we'll say, matters or problems do we have in education in dividing it up?
What are the problems? I think the issue with education is a lot of the decisions have already been made, because the issue is that kids usually are enrolled in a school, whether it's public school within the school district that they reside in, or a private school. So a lot of the times, and before we even get to the issue of problems that may occur, a lot of the times the issue of education has already been taken care of. It's already been resolved just because of what the status quo is. I hate to get ahead of myself here, but the parties, if there are issues, they would be ordered to go to mediation to try and resolve some of those issues themselves.
Okay. Specifically in education, I think we're talking about who attends parent-teacher conferences, who maintains some vigilance with doing the homework with the children. What else can we think of?
Well, yeah, I mean, usually issues of education, like the things like homework and issues of parent-teacher conferences, the legislation has long past had a presumption that the maximum involvement of both parents is in the best interest of the kids. So usually in a parenting plan regarding the issue of education, both parties would attend the parent-teacher conference. Whether or not it's together is another issue. A lot of school districts are very amenable to having two conferences if the parents can't go together. Other issues with regarding homework is obviously whoever has the kid that time is the one who's going to be doing the homework.
Yeah, and we usually write into our settlement agreements that as far as report cards go, it'll be sent to both parents. As far as anything that is an emergency with the children in the class, that both parents would be notified. And it's up to you, you as an attorney for one of the litigants and the other attorney for the other litigant, to get together and talk and come to a compromise along with the parties.
That's true, and a lot of this hasn't really changed. I mean, since the term custody went away on the first of the year, prior to January 1st of 2016, you and I prepared settlement agreements, marital settlement agreements, or parenting agreements, whatever you wanted to call it. Those incorporated all of these issues before. The main difference now is that the courts have the ability to allocate these specific tasks.
Okay. The other category that you mentioned was health. Is that regarding who pays for the health insurance?
It's regarding health decisions.
Health decisions, but not who pays.
Well, I mean, you can agree to anything if you want.
But you could include that in.
Normally, but as far as, or I mean, not normally.
Yeah.
Usually I like to exclude issues, financial issues in a parenting plan or in some sort of parenting agreement and resolve the issues of financial, all financial issues in a separate document like a marital settlement agreement.
Okay.
Because in my opinion, when you start mixing dollars and cents with parental decisions, that creates all sorts of problems, and you want to prioritize ultimately what the the issues of allocation are.
Okay, but in drafting a settlement agreement and regarding that category of health, you would determine with the parties as to who has access to the general family physician or the dentist or the psychologist, and who has access to the records, and who takes the children to these appointments, and how they correlate with each other. And so those are specific things that have to be addressed.
Absolutely. Yeah, you would include, and again, most of the time these issues have already been flushed out throughout their life. One of the new things which the court can take into consideration, it's actually in the new best interest standards in section 602.5, is the past 24 months of the status quo, what has happened in the last 24 months. And this is sort of revolutionary because now we can actually look at, or the court can look at what has been done in the past and kind of say, well, this is what's going to be happening in the future.
Okay, so now, hypothetically, and when we hear this all the time, mom will always say, are you kidding? Him taking the child to the doctor? He doesn't know how to give a shot. Our kid has to take shots every day. This is a problem. So what do you do in a case like that?
Well, I think the dad should learn. Quite honestly.
Okay.
I mean, I'm not sure why the father wouldn't want to learn how to administer medicine for his kid. Something like that it's beyond the scope of what we do here. But if the child has to have a shot every day, then obviously there's going to be days where he's just with the dad, so he should learn.
Okay. The other category you indicated was religion, and that's kind of a tricky subject. How do we handle that, especially if you have two parents who are of different religions? One may go to church, and one may go to a temple, or one may go to, I don't know where else. But how do you handle that?
Well, the court, what the court is limited to do is that it can actually, it's limited to the express desires of the parties or the implied practices. So if a child has been going to the temple versus going to a church, then the court can take into consideration the past decisions regarding the child's religious upbringing. Court can't take that into consideration. But generally, I don't think the court's going to, if you have two parties that say, hey, I want this child to be raised, in Islam, or I want the child to be raised Christian. I think that when you start, if you really do break it down, a lot of courts would probably be less inclined to step into that. It's just if the child has been going to the same church for the last 5 years, all of a sudden, someone finds a different religion, then it might, the court might take that into consideration.
And there's also many outside forces. Dad got a girlfriend, and the girlfriend says, hey, look, I'm going to be part of this family whether you like it or not, and I don't want the child to go to church, and I would rather go someplace else, and so forth. And how do you handle something like that? A new wife?
So you're talking about post-decree litigation, like there's someone that...
I'm talking about as you're working these things out. Let's say Dad's got a girlfriend, and he plans on marrying her, and the girlfriend's going to put her 2 cents into what's going on, even though us lawyers don't hear that. It's going to happen. And do you forewarn the dad not to participate with any conversations with his girlfriend or wife-to-be?
Well, it's obviously these are parental decisions, and a third party should really butt out. But it's something which it depends on who you represent and how important this is. Like maybe parents or the new girlfriend is pretty religious, and dad is starting to become more religious. Then it's something, if you represent him, then you might want to address that differently than you would if someone that just is
Okay,
go ahead.
And we got the next category, extracurricular activities you mentioned. Give me an example of what we're talking about.
Just activities that are in school. Whether the child participates in theater or rather the child participates in wrestling. Those are choices, and a lot of the time, I put in my parenting plans that the parties take significant consideration into the expressed desires of the child.
So you're talking about also who takes the child to, let's say, to Little League practices, who takes the child to wrestling events, and somebody has to do that.
Yes, and what you don't want to do is, and this has been a trap for a while, is that one parent may schedule a lot of events during one time, during the other spouse's parenting time, and you want to try and minimize that. Issues like that come up from time to time. Usually long term, it's not a problem, but you want to be mindful of scheduling stuff on other people's parenting time.
Okay, but both parties are going to have some kind of controversy. For example, if mom has been taking the children or child to all these extracurricular activities, and all of a sudden dad now is given half of the activities, and he's going to have to take them, and she's going to feel left out. I mean, we got a lot of psychological ramifications here.
Well, the issue is that in your story there, it's something which the kids have always participated in, and in my parenting plans, I like to include that both parties are able to attend all the extracurricular activities, and then you have to include. If you think this is going to be an issue, if you have a parent who likes to interact with other parent in a negative way, then you might want to address it a different, rate it, draft some provisions in there about their involvement in the activity, not communicating with other spouse.
Yeah, so you're going to get a lot of vindictiveness in some cases, and some none at all.
Yeah. And
you're going to get a lot of psychological problems in one case and not in another.
And that's sort of the issue that these aren't parenting plans or allocation judgments. Those are not a cookie cutter document. Those are something which you structure for the specific needs of your parties.
I guess what I'm driving at is that this new legislation is not all that it's made out to be. And yes, it's a cookie cutter type of situation, but I think that when you're going to divide up education and health and religion and extracurricular activities that never been divided up before, and you're going to be very specific as to who takes the child extracurricular activities, and then you got a 13-year-old and a 14-year-old who don't want to be with dad or don't want to be with mom. They want to be with their friends. Mm-hmm. And his dad's parental responsibility at that time, or it's his parental time to see the children, and they don't want to. These are problems that we have to work with, and I don't think the new legislation can address these. I mean, there's only so much it can do.
Okay. I've always included in my whether it was a custody judgment or a joint parenting agreement, I've always broken down these categories. These are things which, and I continue to do it, which is why this isn't that big of a shift for me. Hopefully, this is a certain practitioners who didn't do that now will take those specific steps. But the main difference now is the court has the ability to break down these decisions, not necessarily practitioners, but the court. So if this matter were to go to trial, the court can divide up these responsibilities.
Okay. So now we have this parenting plan that includes all 4 categories, and this has to be filed within 120 days with the court after
Correct.
You file your petition for dissolution of marriage.
Date of service, I think.
Date of service, okay. And then there's a lot of pressure on the lawyers and on the litigants to get this done right away, even though 120 days is a long time.
Not in the legal world.
Not in the legal world.
But the one thing, there
Yeah.
are exceptions to it.
Yeah.
The number one exception is if the parties are in mediation. And most of the time,
Okay.
you can't get done with mediation within 120 days.
Now, I know we've touched on mediation in other shows I've done, and other people have done shows on mediation. And mediation is?
Mediation is the parties getting together with someone, usually a facilitative mediator, who will discuss what's important to the parties and try and come up with some sort of resolution.
And he or she does not take any sides,
No,
correct?
No. If he or she usually just lets the parties speak amongst themselves and tries to kind of steer them in the right direction as far as what they can do to come together with some sort of agreement. Which, again, this is an important decision probably the most important decision for these parties, and definitely the most important thing that's going on in their lives at that time. It's best if they have some, if they're involved in making those choices versus a court or versus any other person. So it's best if the
And
parties
that's
do it
probably the
themselves.
best answer I've heard is we weigh, the good and the bad of this legislation, and it probably comes out that it's really pretty good.
I think it's great. I
Okay.
really do.
Now, is the court, in essence, if we look at the bottom line, forcing the parties to parent together?
No, and again, I mentioned before that there's a presumption that the maximum involvement of both parents is in the best interest of their kid. The court's not going to, honestly, the court's not going to try and force two parties who obviously can't get along to parent together. It used to be zero sum. It used to be you file your petition for custody, and the court awards custody to one parent and to another. And that was all they could do. Now the court will take into consideration what the reality of the situation was before. Probably to have ownership and involvement in both parents, which again is what's ideal. Also probably because it's how things have happened all throughout the time. I mean, if one parent has been really involved in extracurricular activities, and one parent has always taken the kids to the doctor, is this something that should really change just because the parties are going through a divorce? I don't think so. I think that the courts, the legislation has injected some reality into the statute.
All right, now, in 2015, before this statute was enacted, we had joint custody. And that was only could happen if the parties were able to communicate with each other. They couldn't have one that's vindictive and hated the other. You had to be able to talk. You had to be able to communicate. If you couldn't have joint custody. But isn't it, in essence, really a joint custody agreement under the new act?
Well, it wouldn't be an agreement if the court makes that determination.
But
what it does is it has taken what you and I have done throughout the years, and the court can now basically do an allocation judgment, which divides up the responsibility. So yeah, I mean, you're right.
Okay. What is the difference between parental responsibility and joint custody, or is that the same question I just asked?
Pretty much the same question. Yeah, they're about the same thing, other than one, the court would make the determinations, another, the parties make the determinations. Now, when we prepare a joint parenting agreement, it's a allocation judgment, which is basically, you take the parenting plan and you modify it, change it around a little bit, and that's the allocation judgment.
Okay.
It's what the parties have decided.
Now, when allocating parenting time, what factors does the court consider?
When allocating parenting time, well, it's again, like I mentioned, the last 24 months of the circumstances. It takes into consideration the kids' wishes. It takes into consider the parents' wishes. It takes into consider the residences where the parties reside.
Takes into consideration a lot of things.
The distance between the residences, child's adjustment to his or her home, school, community. It takes into consideration a bunch of factors.
Yeah, but the court can take in all these things in consideration, but the court also, being the judge, looks at the parties and can make decisions based upon the credibility of the litigants, what they say, what they don't say, their history and so forth, things that are not built into the statute. Is that a fair statement to make?
Yes, the court, it's like any other type of civil action. One of the things which the judges, and most judges are very good at doing this because they do it all the time, is they weigh the credibility of witnesses, which behooves an attorney to prepare their client well for the hearing or for the trial.
Yeah.
It also, what I like to do is I use that as a talking point with my client as to try and work out something in mediation, try and work out something with, if there's a child representative,
Yes.
because you don't want to leave those let's say if your client isn't so calm, has anxiety issues, will not make a very good witness. And you and I both know what it's a client who just gets nervous. And you want to make sure that you minimize what could be interpreted as something different than nerves. So you try and work stuff out yourself.
You know, there used to be a safety mechanism to protect the non-custodial parent's parenting time. What happened to reasonable visitation for that non-custodial parent?
Well, it's still there. After the court allocates parental responsibilities, it also allocates the parenting time, and one parent is going to have more time than another. So the mechanism in place is that you have to show that there's some sort of serious endangerment to make any modification, and that's mental, moral, physical danger before you can modify someone's parenting time.
You know, it's been my experience in practicing marital and family law that when you have an agreement under this new act, which is going to be very tedious, very convoluting, it's going to be difficult for the parties to separate. Oh, they will the first week and maybe the second week, but after that, they're not going to refer to it. For example, if the wife wants to have the child on Christmas Eve on even years, and the husband wants to have the child the next morning on the odd years, it becomes very difficult. You have to constantly look at like a charter or a document that is so complicated every time he or she has to have the child, or who's going to take the child to the dentist, who's going to take the child to the doctor. And it's like something you would put all over the house in different pages in different ways just to keep it straight. Now, I think that's a problem under the new act. I think that we've gone too far and we made it too detailed. What is your take on that?
I don't think it's a problem.
Okay.
I just don't think it's a problem. I think that the more detail you put into something, the more ownership the parties can have, especially if this is something they, again, I haven't changed how I practice since the first of the year. You use different words,
Yeah.
but it's basically the same thing. You allow the parties to, again, inject reality, their life, their choices, the things that they've done, and when you do something like that, it obviously benefits the kids because it doesn't change as much.
Looking at it objectively, you're 100% right. But a mother who has wiped that child's lips after he eats and who has taken that dirty shirt he's wearing and put on a clean one and taken him to the doctor and gives him his shots is not going to want to give that up. And you're saying under this new act that she's going to have to.
That's not what I'm saying at all. What I'm saying is that one parent is, regardless of what happened on the first of the year, the parties are going through a divorce. One parent is going to have parenting time, the other one's going to have parenting time. So there's that wiping the face and everything that's done there will be done at the other house by the other parent. It's still going to happen, and it would have happened before the first of this year, or it would have happened 20 years ago.
Yes, it's going to happen. And it's going to be kind of, we'll say, shocking to the mother. We're using her as an example.
I don't know if it's that shocking. And here's another thing: it's as far as who makes the decisions for use the exception or the example of taking the kid to the doctor. If mom's always taking the kid to the doctor, mom can still take the kid to the doctor. That could be her parental responsibility.
Okay, assuming that the parties would agree to that.
Or assuming that the court would order that, because the court can do that.
You know, I'm going to touch on grandparenting time with you, and then I'd like you to discuss what the waiver of a right of first refusal is, or what is a right of first refusal.
Okay.
Go ahead.
What, you want me to talk about grandparenting time?
Please.
There is a provision within the IMDMA which would allow for parenting time. However, it's pretty difficult for grandparents. The issue number one is standing, and in order to have standing, you have to, and what standing is just being able to get into the front door. It's to be able to file action. You have to have specific circumstances which allow you to do that. And if you have two parents, which if they're going through a divorce and one parent says no, you can't, you can't see the grandparents, that might lead to a situation where you can ask for grandparents.
It's shocking because the grandparents are coming over every Saturday night and they're babysitting for you, or they're babysitting during the week, and they're babysitting 3 or 4 times.
Well, the issue is that you can always have grandparenting time during that parent's parenting time. If let's say it's my parents want to see my kids during my parenting time, then that's fine. It's the issues that if a spouse is deceased, or if you have an intact family and someone's asking for parenting time, it's really difficult to do.
Okay, and real quickly, because we're almost here with a wrap, is the fact of right of first refusal. What is that?
Well, within the new statutes, one of the things which can be entered into in the parenting, it's right in the IMDMA, or the new act, is the right of first refusal. And right of first refusal is simply that. If one parent can't watch the kids for a certain period of time, the other parent has the right to have the kids.
Instead of that original parent that you said it can't watch, not giving the child or children to his or her parents
or anyone else, a babysitter. But the problem is with right of first refusal is that it sounds innocuous, but it seldom is. It's usually a fighting point because people will argue over the time period. Does this apply for weekends? What about work?
Well, John Wroblewski, I want to thank you. You've been very helpful because I think we really got into the nitty-gritty here. You're on one track, I'm on another track, and I think that's good. I think there's more psychological problems involved with the new act, and you think that there's less, and then you think it's more concise and strict, and I think it's very convoluting and very difficult to follow. But it's very rewarding, I think, to the people out there to understand that when they sit down with a divorce lawyer, it's going to be a real problem getting an agreement together. And I think that they're going to be coming back to the lawyers as time goes by in their post-decree litigation, means after the divorce. And I think they're going to have some problems. And I think that maybe over the next couple of years, all those things will be cleared up. I think I'm not the only one that recognizes that. And I really want to thank you for your contribution today to this show. And I want to thank everybody out there for watching You and the Law. This is a program presented by the Chicago Bar Association. Thank you.